Good afternoon, everybody. Getting back onto the Stephen Avery, Brendan Dassey, Making a Murderer train. Apologies that I've been sort of sidetracked with the Speedway stuff, but it's really starting to take off, which is great. And for those that think, well, you should concentrate on Making a Murderer, the cross-pollination is amazing. One of my guests on Thursday night on the Speedway live chat actually got in touch with me, not to do with Speedway, but about the Making a Murderer case, and he's a former Berwick rider. And so there is the possibility that people who will join and tune in to listen to one topic will then become interested in the other topic. So let's carry on now with, we're looking at, obviously, Ken Kratz. Is there a more perverted district attorney in American legal history? Probably, but he's the one that we all know about. Sad thing is, he isn't a rarity. There are quite a few like this who think they're above the law, not least, of course, over there on the staircase. Poor old David Rudolph had to put up with Jim Harding for how many months, years. Anyway, looking at the fallen Ken Kratz, we got up to this item number 7, I believe it is, but I've got it here anyway, so let's pop it up. Office of Lawyer Regulation versus Ken Kratz. And we got as far as, in the end, there is nothing extraordinary here from a cost perspective. Our general rule is to impose full costs upon a finding of misconduct, and we do so here. 68, it is ordered that the license of Kenneth Rapist Kratz to practice law in Wisconsin is suspended for a period of 4 months, effective July the 11th, 2014. He wanted it, of course, backdated, no chance. It is further ordered that Kratz shall comply with the provisions of SCR 2226 concerning the duties of a person whose license to practice law in Wisconsin has been suspended. It is further ordered that within 60 days of the date of this order, Kratz shall pay the Office of Lawyer Regulation the costs of this proceeding. It is further ordered that compliance with all conditions of this order is required for reinstatement, I join the per curiam opinion. I presume this is Shirley S. Abraham concurring. So this must be her carrying on. The OLR disciplinary system is about 15 years old. Several anomalies and proposed amendments have been brought to the court's attention. It is time for the court to institute a review of the system rather than to make that scared the dogs. Piecemeal adjustments at this time. See my writings in OLR versus Johns, OLR versus Osaka, OLR versus Osaka. Okay. Let me just close that. Oh, hold on a sec. Let me just pause this one moment. All right, there we go. Sorted out. Change of lesson time, but easy fixed. We were looking at, I think it was the writings of Shirley Abrahamson, yeah, I believe. And item 74, I welcome Justice Prosser's support for an impartial, objective, thorough review of OLR practices and procedures, support he gave at the Open Rules Petition Conference in 2013 for a history of a proposal for such a review, listened to the Open Rules Petition Conference of October 2013 in connection with proposals for change in the OLR's practices. You know, it's Ken Kratz has brought all this along. The question of instituting such a review will come before the court again. I hope it will get 4 votes. David T. Prosser, concurring in part Dissenting in part, from time to time, every government agency would benefit from an impartial, objective review of the agency's practices and procedures. There is increasing evidence of the need for such an evaluation of the Office of Law Regulation. This case highlights some of the problems facing the agency and why an objective review would be desirable. If Ken Kratz had simply stuck to his oath, I don't think you would have a problem, to be honest. It must be stated at the outset that the misconduct of Attorney Kratz requires discipline. I concur with the recommendation of the referee that Kratz receive a 4-month suspension, which is the suspension approved by the court. OLR wanted a 6-month suspension. A 6-month suspension would require Kratz to seek readmission from this court, a process that often takes the better part of a year. A suspension of that duration would have been unreasonable? I don't think so. OLR has also asked that Attorney Kratz pay all costs of the proceeding, namely nearly $24,000, and the court approves these costs contrary to the, this is the only problem with it being written this way around, recommendation of the referee. The exorbitant costs required by OLR and granted by this court require discussion and prompt this partial dissent. OLR charged Attorney Kratz with 11 counts of misconduct. The first 4 counts involved SVG. One of these counts was later dismissed by OLR. The counts involving SGV are the reason why Attorney Kratz requires discipline. They are described in 7-22 of the per curiam opinion. Attorney Kratz's conduct was highly inappropriate and cannot be defended. What is important for this concurrence dissent, however, is that the substance of these counts, including all text messages between Attorney Kratz and SVG, was self-reported by Kratz. Only once he could see there was no way out to OLR on December 4, 2009, making proof of ethical violations easy to accomplish. Thus, one of the first issues to examine is why OLR did not file any charges against Attorney Kratz until November 30th, 2011. That you do have a, what's his name again? Prosser. Yes. Prosser, you do have a point there. Why did the OLR not file charges earlier? It seems obvious in retrospect that Attorney Kratz suffered a serious breakdown of some sort. No, no, Prosser, no. That's just his nature. That's just how he is. Of some sort by October 2nd. He had been through considerable stress from 2005 through 2009 as special prosecutor in the high-profile murder trials of Stephen Avery and Brendan Dassey in Manitowoc County. Post-conviction proceedings in Dassey's case were still pending in the fall of 2009, culminating in a 5-day hearing in 2010. Attorney Kratz and his then wife separated in October 2009. I do feel sorry for her. During this stressful period, and he began to abuse prescription drugs. Whether these stresses and difficulties contributed to Attorney Kratz's October conduct is speculative, but the stress and difficulties are not, I'm not having any sympathy for him whatsoever. Once you look at the full facts of what he did. The referee in this case, former County Circuit Judge Robert Kinney, wrote the following in his report and recommendation to the court. Perhaps the most perplexing aspect of this case is the seeming incongruity between some of the respondent's professional accomplishments and the inexplicable behavior which he engaged in, which brings him before the court now. No, it doesn't. No, it doesn't. It absolutely explains it. When you study what sort of person Kratz is, it's not surprising at all. The respondent was appointed special prosecutor in the case of the State versus Stephen Avery. This was a high-profile case with statewide media coverage. During this time period, the respondent testified he had trouble sleeping and was prescribed the drug Ambien. He testified he received it. Shortly thereafter, people observed a change in his behavior. The respondent testified that he had been prescribed Xanax for anxiety attacks and was taken leftover Vicodin, which had been prescribed earlier after he underwent surgery. The respondent testified that he developed a dependency on Ambien and Xanax. He testified that he believes the use of these drugs diminished his inhibitions and caused his speech to be more unfiltered. Counts 1, 3, 4, 5, and 6 are based on incidents that occurred during 2009. No date is given for the incident in court. Count 7. Attorney Kratz's unacceptable text messages with respect to SGV took place over a period of 3 days in October 2009, approximately a week after the separation from his wife. You're not slow in moving, are you, Kratz? On the third day, Stephanie took the matter to the local police. Within 2 weeks, Kratz had removed himself from the criminal case in which Stephanie was the victim. Not sure about that. I think it was more pressure came on him. After the Wisconsin Department of Justice was notified of Attorney Kratz's conduct, it pressured Attorney Kratz to resign as chair of the Wisconsin Crime Victims' Rights Board and to self-report his misconduct to OLR. He did the latter on December 9th, admitting his conduct and expressing his embarrassment for it. When the Office of Lawyer Regulation received Kratz's communication, including all the text messages, it commenced an investigation. Thereafter, on February the 4th, 2010, OLR received a grievance from Stephanie on October 18th. An OLR investigator wrote to Stephanie asking that she contact the investigator. On March 5th, having received no response from Stephanie, the investigator notified Stephanie that the matter had been closed. Attorney Kratz was notified of this action in some 3 months after it received all the information necessary to prosecute Kratz, and barely a month after receiving the grievance from Stephanie, the OLR closed the case. The record does not indicate why Stephanie did not follow up on her grievance. The record does not. I would imagine because she wants absolute bugger all to do with anybody from to do with lawyers. The record does not indicate why the OLR closed the matter when it had ample evidence to proceed if it wished to do so. OLR's letter to Stephanie stated that Attorney Kratz's conduct did not appear to involve possible professional misconduct. 6 months later, Keith Sellen, director of the OLR, was contacted by Ryan Foley, yes, the reporter for the Associated Press. Sellen later indicated in an affidavit that he had not been aware of the Kratz matter before the Foley inquiry. The following day, September 15th, Foley wrote a news story based on information he obtained from a police report released by the Kaukauna Police Department. Foley did not reveal how he learned about the police report describing Kratz's conduct. Foley's story triggered a political firestorm less than 2 months before the 2010 general election. There were immediate calls for Kratz's resignation. When Kratz did not resign, Jim Doyle initiated proceedings to remove him from office. The Kratz matter became a political issue. Scott Hassett, the Democratic candidate for Attorney General, accused his opponent, incumbent Attorney General J.B. Van Hollen, of knowing about the Kratz matter for nearly a year and doing nothing about it. Democratic Party Chair Mike Tate accused Van Hollen of a cover-up after discovering the sexually harassing text messages. Well, it is true that Kratz wrote to and specifically named J.B. Van Hollen as being somebody that he had, yes, fellow Republican and political ally Ken Kratz sent to a woman whose boyfriend he was trying for nearly strangling her to death. To Jim Carter, fallout with Calumet County District Attorney Ken Kratz takes on political tinge. Challenger Scott Hasnett says Attorney General Holland knew about District Attorney Sexton case but did nothing about it. Press release, the Democratic Party of Wisconsin JB Van Hollen's Ken Kratz cover-up continues. Attorney General Van Hollen responded to these attacks with assertions that the DOJ pressured Kratz to resign from the Crime Victims' Rights Board and advised him to self-report his conduct to OLR. There are no bones about the fact that the Office of Lawyer Regulation dropped the ball here. Van Hollen told the Post-Crescent newspaper in Appleton. He said he was surprised to learn that OLR had told Stephanie that Attorney Kratz's conduct did not appear to involve possible professional misconduct. I personally am very concerned with the fact that the Office of Lawyer Regulation determined there was nothing wrong with this activity, he added. Jim Collar, Wisconsin Attorney General Van Hollen, criticizes OLR for its handling of case involving Kratz. See interview with Dan Flannery. Let's go back up. Wisconsin Attorney General Van Hollen criticizes OLR over its handling involving Calumet County District Attorney. OLR, having now received a letter from Stephanie's attorney, Michael Fox, reopened the Kratz investigation. Additional complaints came in. More than 13 months later, OLR filed its complaint. From all appearances, OLR was determined to make up for dropping the ball. It selected as outside counsel Thomas Basting, who filed 11 charges against Kratz, including 7 counts related to 4 new matters. In one of these charges, OLR essentially accused Kratz of sexual assault. After various phone conversations, Kratz asked to visit JW at her apartment. JW asserts that Kratz arrived at her apartment and, after threatening JW, forced her to have sex. On September 28, 2010, JW provided the information about Kratz to her probation officer at the Department of Corrections. The DOC reported the issue to the DOJ. The DOJ interviewed JW, who provided a statement. The statement alleges that Kratz, while district attorney, had forcibly sexed with an emotionally vulnerable woman after previously prosecuting the woman. In filing its sensational charge pertaining to alleged sexual assault, OLR not only discredited Attorney Kratz, but also implicitly criticized the DOJ and local law enforcement authorities for failing to prosecute him. It later quietly dismissed the charge. As noted above, OLR also asked that Kratz be suspended from the practice of law for 6 months. Looking backward, OLR forced Attorney Kratz to defend his law license to avoid being required to apply for readmission to the bar and to defend himself against alleged criminal conduct. Kratz admitted the Stephanie counts, but disputed that he should be suspended for 6 months because of them. In time, OLR dropped 5 counts, including the alleged sexual assault count. The only new charges on which OLR prevailed were 3 counts involving tasteless sexual comments that Kratz made in two co-workers. The 2 co-workers in counts 5 and 6 acknowledged that Kratz's comments were out of character and that Kratz apologized and told her his comments were inappropriate and he should not have made them. The co-worker in count 7 also said Attorney Kratz's comment was out of character. I'm not sure about that. You've got to know him. In the years following Stephanie's complaint to Cook County Police, Kratz was forced to resign as district attorney. He went through a divorce, he lost his home, and lost his car. He was no longer the prize. He was sued by Stephanie and settled the lawsuit. He filed for bankruptcy. It is unlikely that Kratz is in any position to pay $24,000 in court costs. Excellent. These extravagant costs will pose a serious hardship to Kratz. Good. Cannot be justified on the basis of the OLR prosecution and are manifestly unfair. I don't think you'll get any sympathy here. I think we're pretty close to the end of them, but let's just go through them. Nearly there. The Kratz case underscores the need for a thorough review. First, OLR closed the investigation of Kratz without the knowledge of the OLR director, Stephen Sellner. How did it happen? Kinney wrote the respondent's letter, which self-reported the incident involving SGV was received by the OLR on December 8, 2009. The matter was closed March 2010 when the investigator received no response to her February 18th letter to SVG. The respondent was advised that the matter was closed at that point. It was then reopened by the OLR more than 9 months after the respondent self-reported the incident. The case simply sat in limbo for 9 months while reports of other violations were then received. The closing of the file in March was obviously a mistake. Second, after reopening the investigation, the OLR took 13 months to file a complaint against Kratz. What is the justification for this long lengthy delay? Third, after a long investigation, OLR filed 3 sensational counts against Attorney Kratz that it later dismissed for lack of proof. Why did OLR's preliminary review committee permit these counts to be filed? Is the preliminary review committee serving its intended purpose of screening out improvident charges when it approves 98% of the OLR staff's recommendation? A, 98% approval rate is the percentage OLR Director Keith Sellen recently cited in his October 25th, 2013 testimony on rule petition before the Supreme Court. Fourth, OLR expects Attorney Kratz to pay all costs related to the prosecution of its improvident charges and its harsh desired level. Discipline should a respondent attorney be expected to pay OLR's costs for charges that are not proven and a level of discipline sought but not imposed. Fifth, OLR appears to be unwilling or unable to drop charges it has filed unless it acknowledges that the charges cannot be proved. It could likely have settled the Kratz matter much sooner if it had been able to bargain for something less than unconditional surrender. Should OLR have the authority to plea bargain with respondents? If so, under what conditions? Yeah, okay. I think we've been about there. No doubt other questions could be raised about OLR's handling of the Kratz case, but apart from this single case, there are many reasons for this court to launch a thorough, strictly objective review of the agency. If that review is undertaken, something useful may yet come of this unfortunate, no, it's not an unfortunate tragedy. It's one guy finally getting to answer for the way that he is. Okay, I thought there might be a signature or two at the bottom, but quite a lengthy opinion. But I think the main opinion was by William Griesbach. So I think so, yeah. But I think all they did was basically accept retired Judge Robert Kinney's opinion. Anyway, let's stop it there. Finally, we got to the end of Kratz's fall and fall, and he continues to fall. He tried to get himself back again. He was desperate to try and sell books, and he probably sold a few, made himself a few bob, went on a few shows and went to a few conferences. I have heard nothing of him since. No idea what he's up to now. If he's got any sense, he'll shut his mouth and go away. Well, actually, if he's got any sense, what he could do is he could certainly help with Brendan Dassey, because he actually wrote to Tom Fallon and said, you know, can we look at Brendan's sentence and get it reduced now, because he served, you know, so many years, well, over 10 years at that time. I mean, at the moment now it's coming up for 15 years, isn't it? But it'll be over that. Well, when you consider he was arrested in 2006, that's 16 years. Yeah, maths wasn't one of my greatest subjects, unlike the dude. Anyway, I'm going to say cheerio, and we'll catch up with you soon. I'll say if you're around on Thursday night, I'll have a chat about Speedway, but it's 8 o'clock UK time. I'll catch you all soon. Anyway, take care. Bye for now.